What are the key considerations for potentially hiring a foreign national vet for your animal hospital or clinic? That's what we're talking about on today's Live at Lunch. My name is Emily Sumner with Sumner Immigration Law, and I'm so glad that you're joining us, whether you're joining us live or catching the replay. So, again, we're talking today about what are some key considerations when you're thinking about hiring a foreign national vet for your animal hospital or hospitals, a system of hospitals. This is something that we're not able to cover every single detail, of course, in the course of the next 10 or 15 minutes, but we're going to talk about some high level considerations, including thinking about the options that you might have available or that the foreign national might have available, what the cost might be, and what the timelines might be. So stick around if you want to hear more. One thing to keep in mind is what we're talking about is specific to vets, but it's also applicable to a lot of other industries and professions as well. Within US immigration, there are some idiosyncrasies sometimes depending on the profession that we're talking about. But in general, what I'm talking about applies to any number of different professional occupations. So stick around even if you're not in the vet med space. So what are some key considerations? The first thing is, what are the options to bring a foreign national vet to the United States or to hire somebody who is already in the United States to work for your particular animal hospital? And the answer for that is, of course, it depends. For almost every letter of the alphabet, there's a different visa classification and then subclassifications within those. Those are called non-immigrant visa classifications or temporary visa classifications. When I say temporary, they can last for several years depending on the visa classification. So it's not, we're not talking about like 6 months at a time necessarily. But there are some visa classifications that are commonly used for vets, and like I said, other professionals as well. We'll talk about those high level. I also have a lot more detail about each of these visa classifications on my website and also in our video library called Sumner School Business Immigration Basics, which I will put in the link to this video. So the first most commonly used visa classification is, of course, the H-1B visa classification. That can be used. It can be a great solution. One thing to keep in mind is if your particular candidate has never worked in H-1B status before in the United States, they're probably going to be subject to what's called the H-1B cap. There's a numerical limitation on the number of H's available every year, and there's a lottery that happens every year. It happens in March. That registration period is also about to open in March of 2025. And we have a lot of information available on our website. We actually have a web page on our website devoted just to the H-1B cap information. And I'll also be talking about it in next week's Live at Lunch. So keep that in mind if you're interested in the H. Also keep in mind that it's not, the H-1B visa classification is not just limited to this lottery situation. It is possible to hire a foreign national vet or other professional who is already here in the United States in H-1B status working for another employer. That is called an H-1B transfer. In addition, it's possible for a person to work on a concurrent H-1B. And I'll tell you a success story about that in a few minutes. So know that the H-1B is one visa classification. Again, we're not able to get into a ton of detail here, but know that that's a possibility, but there are certain limitations, namely the numerical cap. That numerical cap, by the way, is 65,000 new H-1B petition or slots available every year, plus an additional 20,000 for U.S. master's degree holders. The chance of being selected in the lottery depends, of course, on how many registrants there are. In the past 2 years, the chance of being selected in the lottery was about 26%. Other commonly used visa classifications for vets include the TN visa classification. That is for citizens of Mexico and Canada. That can be a great option. It is different from the H-1B in the sense that the way that you apply is a bit different. And the fees associated with that can also be lower. The H-1B one is for citizens of Chile and Singapore. I have a number of clients who have vets who are working on H-1B one. Similarly, the E3 is for citizens of Australia. And that is, I also have a number of vets that are working on the E3. A less commonly used visa classification that could be a possibility, I've done it before for a vet, is H3. That's a training visa classification. So I have used that before, for example, when a vet is working in a very specific residency program. There are certain requirements that you have to show. It's not very common. And the idea is the person would be training here in the United States on the H3 and then go back to their home country to apply those skills. So less commonly used, but it's a possibility as well. And then, of course, there is the green card process. It is possible to sponsor a vet for the green card process if they are currently working for your practice, your hospital, or if they're not. It can be done for future employment as well. The green card process we'll talk about in a future video more specifically, and I have a series of videos, like I said, in Sumner School Business Immigration Basics on that. But know that the green card process can be an alternative potentially to the H-1B cap. I say potentially because it is going to take a much longer amount of time to get through the whole green card process. So it can be used as an alternative, or it can be used to retain talent. So if you have hired somebody on one of these temporary visa classifications, it can be possible to sponsor them for permanent residence. And that can be a way to help them be encouraged to stay with you for a longer period of time, and just to show that you support them and that you support their immigration journey. So what is the timeline for these visa classifications? What is the timeline if you want to hire a foreign national vet? How quickly can they begin working? And what is the documentation that you need to share with the immigration lawyer who's helping you prepare this? The answer, of course, is it depends. For every visa classification and really every situation, it can be very fact specific. But let's take an example of a person who is working in H-1B status for another vet hospital, for another animal hospital, and they want to transfer to your hospital. This is something we do all the time, including we filed one of these yesterday, specifically for a vet. So the timeline is that probably from the time you start the process to the time that we're able to file the H-1B transfer petition would probably be about 2 or 3 weeks, realistically. We could potentially get it done in about 10 days. One of the things that takes the longest is the LCA, the labor condition application that you have to refile on your behalf with Department of Labor, and that takes 7 days to be certified. So that's a restraint. That's why we can't do it overnight, literally. But realistically, with gathering the documentation, working with the client for the first time, it would probably be about 2 or 3 weeks. One thing to keep in mind for an H-1B transfer, this is different from a person who is coming, maybe you registered them in the H-1B cap with the lottery, and they're coming from overseas or transferring from changing status from a different visa classification. For the H-1B transfer, if the foreign national is working in valid H-1B status, or if they meet certain requirements, if they're in a 60-day grace period and their other requirements met, we can walk you through that. They can begin working for the new employer for your practice as soon as USCIS receives the petition. So it does not have to be approved. It can. You can say, yes, I want to wait for this to be approved, but that doesn't have to be the case. So like I said, from the time you start the process to the time that they're able to begin working is typically within a month or less. In terms of the documentation that you need, again, it depends, of course, on the type of filing that you're submitting. But in general, we as the immigration lawyer do need information. We try to streamline this as much as possible. I know that for whether it's medical directors or practice managers, whoever it is that our contact is, I know that this is not your primary job and that you are very busy. So we try to streamline this as much as possible, but it's also important to us that clients be educated about what the process is, what documentation we'll need, and what's involved. So in general, the types of information that we'll need, whether we're doing an H-1B or a TN, H-1B1, things like that, are some basic information about the practice, like the full name of the entity, maybe some corporate formation documents. The FEIN, the federal tax ID assignment letter, is helpful to have. And then information, we have a questionnaire where we ask you how many employees do you have? What is your address? What's the name and title of the person who's going to be signing the documentation? Basic information like that. We always tell clients if there's something that you're not sure of or you're not sure what it's asking, let us know. We're happy to help you out. In addition, we need information about the foreign national. So for example, what salary is being offered? What are the work site locations where the person is going to work? Things like that. And then if there's a more specific job description, that's pretty helpful. That can be helpful. For a vet, it's pretty straightforward most of the time. But there can be specific things, they might have a specialization or specific tasks that they're going to do. So that can be helpful as well. From the foreign national, we need information like a copy of their passport, their current immigration documentation, current pay stubs if they're working in the United States, copy of their resume, things like that. And we coordinate with the foreign national to get that information. In terms of costs, again, this is very case specific. So unfortunately, I'm not able to say it costs X amount of money to sponsor a foreign national for to work in the United States, because again, it depends on the type of case and so many other factors. So for example, within the H-1B realm, let's say that you're going to sponsor someone for an H-1B transfer. This isn't a CAP registration type situation, but an H-1B transfer. Then that means you're going to pay the legal fee, which is the fee that you pay to the immigration lawyer. And then you're going to pay separately the government filing fees. So the legal fee, if you're interested, contact me. I'm happy to share that information. Usually for an H-1B, it's in the range of a few $1,000s, really depends on the immigration lawyer that you're working with and a number of other factors. The fees, the filing fees itself depend on whether the practice is a nonprofit or not, and the size of the entity. So it can range anywhere from like $1,500 to a few $1,000s. So I know that's not helpful, but again, I'm happy to help individuals figure out that information based on how many employees you have. The kind of cutoff is 25. If you have 25 or fewer employees, there's a lower filing fee. And then more than 25, there's a higher filing fee. For nonprofits, there's certain they have the lower filing fee, and then there are certain fees that they don't have to pay. Sometimes you have to pay a fee. I'm making this sound really complicated, and it is. The filing fees are a little complicated. So again, happy to help you work this out. But there are certain fees that you pay just for the first time that you file a petition for someone. Then if you file an extension, you don't have to pay that fee again. So again, we're here to help you navigate all of that and help you get a more exact estimate before you even begin the process. So compliance and responsibilities. After you file the petition, whatever it is, whether we're talking about an H-1, a TN, H-3, H-1B1, whatever it is, what are the things that you have to do to ensure you are complying with immigration law? We walk you through that step by step. We make sure that you have all of the paperwork that you're required to keep on file. And again, what you have to do depends on the specific visa classification. For example, for the TN, there's really not a lot that you have to keep on file. Just in general, you have to make sure that you are not, and this is true whether you're sponsoring foreign nationals or not, but you have to make sure you're not engaging in national origin discrimination, for example. If you hire a foreign national in general, you have to make sure that you pay them and give them the same benefits that are available to other workers as well. For the H-1B or the H-1B1 or the E-3, which are all classifications that require a labor condition application, there's a set of paperwork that you have to keep on file called the public access file. We make sure that you have that. We create that file for you. We give you very specific instructions on how to maintain that file. We're always available to answer questions as you have questions throughout the duration of your foreign national's employment with you. In addition, you do have to comply with certain, for the LCA-based filings, like the H-1B, H-1B1, E3, you do have to pay the foreign national a certain amount. It depends on the prevailing, it's called the prevailing wage, either the prevailing wage or actual wage. Actual wage is what you pay similarly employed employees. So basically, like I said, you have to treat it's I think pretty reasonable. You have to treat foreign nationals the same as you would another worker and commit to paying them that amount throughout the course of their employment. So let's talk about a success story. I have had, they're all different types of success stories. Some are pretty straightforward, kind of boring. But I have had a situation before where I just started representing a corporate entity that has a number of vet hospitals around the country. And they had been working with a number of different immigration attorneys. They had a case that had already been filed, an H-1B transfer that had already been filed. And in this particular case, unfortunately, there were a series of missteps in the filing. I won't get into all of that, but it was not salvageable. That particular filing, and it ended up that person needed to be counted against the H-1B cap, and they didn't realize that previously prior to filing. Anyway, I won't get into all that, except to say that we were able to come up with a solution. So this particular vet was able to, and this is easier said than done for sure. So I'm not saying, oh, this is just a walk in the clouds and it's totally fine. But there are creative solutions. In this particular situation, the employer really wanted this person. So the hospital really wanted this person. This person was able to obtain a position. They already had a connection. There goes my dog. They had a connection with a university. And so the person was able to get a job offer with the university. Universities are CAP exempt organizations. It has to be a true job offer, right, for this to work. And it was in this particular situation. So in this situation, the vet was able to work part-time at the university, and they had a concurrent H-1B with my client who was otherwise CAP subject, and they were able to keep working not keep working, but they were able to start working with my client while they held that H-1B position with the university as well. Then when the H-1B cap, and I say that because it's called a concurrent H-1B. I have a video on this as well. And if you are working for a CAP exempt organization like a university, you can also, as long as you're working for that organization, and again, it has to be a bona fide job offer, it has to be a true situation. But as long as you're working for that organization, you can also have a concurrent H-1B and work at another CAP subject organization as well. So that's what they did. We registered them in the H-1B lottery, and subsequent years, unfortunately, they were not selected in the H-1B lottery, at least the first couple of years. At the same time, as soon as this person began working for my client, we started the employment, or my client started the employment-based green card process for this person. So they were able to keep working at the university, keep working for my client. And then once we got to the green card, the point in the green card process where they were able to get work authorization, they were able to stop working for the university and work just for my client, and ultimately got the green card. So that is, like I said, definitely easier said than done, but it is feasible. There are creative solutions out there, sometimes, a lot of times, that you don't necessarily think of right off the bat. So keep the hope alive, keep the faith alive that you can get this top for our national talent and keep them here in the United States. So I'm going to wrap it up here. I hope that you have found this information helpful. Like I said, this information applies not only to vets, but to other professionals as well. And we serve vets, people in the vet med industry, we have clients in the vet med space, but in other industries as well. So if you found this information helpful, I hope that you will share this video with a colleague or a friend, and subscribe to our channel on this platform, wherever you're watching it, so that you don't miss our next episode. My name is Emily Sumner with Sumner Immigration Law, serving clients throughout the United States and around the world with employment-based and family-based immigration matters. We will be back next week for Live at Lunch on Tuesday at noon Eastern. Until then.